Good afternoon and welcome back to KW Property Management and Consulting's Best Practices monthly webinar for community associations. I'm your host, Tim O'Keefe, an executive director and partner with KW Property Management and Consulting. Last month, we went back to the topic that served as the catalyst to start these educational webinars almost 2 years ago. We addressed the resurgence of COVID with Dr. Josh Lenches, the Chief Medical Officer from Broward Health Systems. Now that Omicron surge is declining fast in the US, many states are lifting their mandatory mask requirements. In property management, most associations are still requiring employees and owners to wear masks when indoors in common areas like elevators, fitness centers, card rooms, and the lobby. To date, 64.7% of Americans are fully vaccinated, and a little bit more, 65.6% or more than 14 million Floridians are fully vaccinated. Last month, the government offered free COVID kits by submitting an order at covidtests.gov. I learned over Christmas that it's much more convenient to have a test kit in our homes before we need one. So once you need a kit, they may be too hard to find. I submitted a request for a kit last month and it arrived on time about 2 weeks ago. If you have not ordered your free kit, you can do so at covidtests.org. That's my public service announcement for today. Okay, so let's move into our discussion for today. The first quarter of the year is election season for many community associations. Today, we're going to address best practices for managing the election process. We have a great panel of experts joining us. If you have a question, please find the Q&A icon on the bottom of your screen and type in your question. We will do our best to answer all the questions that we received today. So with that, I want to introduce our panelists. First, MBender. Mike is a firm member with the Kaye, Rembaum law firm specializing in community association law. Mike is an active lecturer on all topics relating to association law. He has served on the Florida Bar Grievance Committee for 2 terms and has been appointed to the state's task force to help with the reopening of the state's economy due to COVID. Welcome, Mike.
Hello.
Andrew Black also joining us as a firm member with KWPMC Rembaum. Andrew specializes in his law practice in all areas of community association law for HOAs, condos, and co-ops. Andrew will be joining me in 2 weeks to host a board certification course on March 3rd. Welcome back to the program, Andrew.
Thank you so much. Happy to be here.
Thank you. And last but not least, we have Zuly Maribona. Zuly is a senior vice president and partner with KW Property Management. Zuly is responsible for the service level and operations of our company in Naples, Fort Myers, Tampa, Orlando, and Jacksonville markets. Welcome back, Zuly.
Thank you, Tim. It's my pleasure to be here.
Well, thank you, guys. I know you're going to be awesome. So we have poll questions today that all the listeners can respond to during the webinar. Now, if you have a question for our panelists, again, look at the bottom of your screen, find the Q&A button, and send your questions to me. Zuly, let's get started with you real quick. What are some of the best practices that an association should consider leading up to their election process?
So great question, Tim, and thank you. First and foremost, both the association and the team, the management team, play a very important role in this process. And we have to be strategic leading up to our annual meetings and our elections. First and foremost, we should have a plan. We talk to our management team all of the time and also our board of directors of preparing for this process, coming up with your timeline, establish your timeline well in advance. So typically most of our associations have their annual meetings right around this time of year, first quarter of the year. So rewind your calendar, talk about what timeline you have to set for your meeting, then look at your documents. Always review your documents, establish what your quorum requirements are if you're going to have an election, if you have amendments that you are trying to set out as far as votes. So what type of quorum requirements do you have for either of those votes? And then really, once you've reviewed that, then you would want to then consult with your attorneys. Obviously, we have our legal support here, and they can talk about that a little bit further. But really establishing a timeline of the date requirements for the annual meeting date, what it would look like to then prepare for that annual meeting, because there are, depending on the association, first notices involved. There are an array of documentation that needs to be prepared in advance of that first notice. Potentially, there could even be committees that need to be formed in order to establish a nominating committee for a board of director election. So really it's trying to be as open with communication with the community, establishing a timeline and being strategic in the communication and also in the organization leading up to the annual meeting date.
Okay, our attorney friend, what would you add to that as far as what board should be thinking about for best practices leading up to the election?
I mean, I'll go first. And again, that was pretty comprehensive. So there's not a lot to add. I think I'll reiterate the importance of understanding your governing documents. And I will remind everyone on those of you who are on, both managers and board members, the manager should be looked at to guide, but shouldn't be burdened with now analyzing what the documents say. So that's really, to Zuly's point, that's where you want to bring your counsel involved, get your counsel involved, and make sure that you're following the requirements of your governing documents. The condominium world is a bit different. It is a creature of statute specifically, and those processes and the notice requirements are pretty standard. But in the HOA world, there certainly are differences. It's certainly not a cookie cutter situation. So understanding your documents well in advance, and in the condo world, it's a minimum of 60-day first notice. So I would say go 90 to 120 days out and have an understanding of what your process is for your election. New board members, you're elected, you have a few months to get your feet wet, and then the process will start over again. So I think that's what I would add, is just definitely be aware of what your requirements are in your documents, because they're not all the same.
Okay, excellent. So let's say I was somebody that actually loved reading state statutes. Where would I find in statute 718 and 720 that addresses holding elections?
Sure. So for condominiums, obviously there's an entire chapter. It's chapter 718 of the Florida statutes. You all know that's the Condominium Act itself. There's various election and meeting provisions in 718.112. There's even some language in 718.111. There's the Florida Admin Code, which is actually a separate set of laws that deals with elections. But as Mike said, we don't like surprises in the attorney world. So preparation is key. Do you know who's eligible? Do you have to be an owner? These are all things that your governing documents will state. Do you require what's called voting certificates if a unit is owned, or a home is owned by more than one individual or owned by a corporation, to identify who the authorized voting person is? So all of these things can be known well in advance of the meeting itself. Getting back to your question, Tim, for HOAs, it's in chapter 720.303. And what the HOA statute essentially states is, look to what your governing documents say. In HOAs, the documents will outline what the election process will be. Most, not all, but most governing documents in an HOA will have a detailed election process. If not, there's default language in chapter 720 to explain how that election process will go.
So that's a good point, Andrew. So if you happen to live in an HOA and you moved into a condo, don't assume that the laws are the same, because they're not. There's different requirements with proxies and quorums. And so make sure you understand what the law is. So 718.112 and 720.303 is where you can find law if you just love reading that stuff. Or do it the way I do. Call your attorney and ask them what the best way is to do it. That's a quicker process.
And yeah, and I would also point out the state agency that governs condominiums, the Division of Florida Condominiums. They put out lots of good education resources as well. Managers can certainly use it. They have a whole flow chart that outlines when the first notice needs to be sent, when if someone wants to be a candidate for the board, when that notice of intent needs to be, turned in. So there's lots of good free information out there as well.
And that's all great stuff, Andy. And the DBPR, while it is a division of condominiums, their jurisdiction for in the HOA world is limited, and it does extend to elections. So you can use it, you can look to them for a little bit of guidance, but primarily, as Andy said, you're really guided by your governing documents in the HOA world, whereas the condominiums, the creature of statute. And I would also, and I will pitch that the what you just put in the chat, the condominium board and HOA board certification that Andy's going to be doing with you guys in a couple of weeks is a great program for board members to get better understanding of the election process. That's one of the chapters of his course that we go through and go over is the ABCs of running your elections. So that's another great resource.
Great, thank you, Michael. So let's talk about, preparation. There's advanced preparation months in advance for the election, and then there's the requirements by the statute. So can you all talk about what are the milestones from a timeline standpoint that must be met to have an official qualified election? There's a first notice, candidate notice, second notice. Can you give those dates just to remind everybody what's required?
Yeah, and what I'll do is, and I'll clarify again, I'm going to speak first the condominium world and the cooperative world. If there's anyone in the cooperative world, it mirrors the condominium world, to my knowledge. Right, Andy? I got that right? Andy's my co-op. Right. Andy's my co-op king. So the condominium world is very, again, creature of statute. Your first notice goes out 60 days prior to the date of the election. And in that first notice, you're inviting those who are eligible to submit a notice of intent to be a candidate. And that first notice will give the specific deadline, which is 40 days prior to the date of the election. And that is a hard and fast date. Whether it's a weekend, whether it falls on a holiday, that's a hard and fast date. So if there's someone who's interested in running for the board, they need to have that notice of intent to be a candidate in to the location where it's supposed to be provided by the date. And if there's a deadline time, like if it says this date by 5 p.m., sometimes they have time, sometimes they don't, but it needs to be in that date. And not the, so if it falls on a Saturday, don't deliver it Monday, you're not going to get in. You're not on the ballot. So that's a hard and fast date.
What happens if I come to you and say, oh, Michael, I've been on the board for 5 cycles. I'm running again. I got my notice in on day 39, not day 40. You knew I was running. It's not a big deal. Just, I'm going to run. Put me on the ballot.
Well, they wouldn't say that to me. They would say that to you because you're the ones. But if you would come to me and I would say, unfortunately, board, longtime board member, being a longtime board member, you absolutely knew of these deadlines, and so you're not eligible to have your name on the ballot if it was not timely submitted.
If it was past the deadline, correct?
Yep. If it was not timely submitted, then that's why I said it's a hard and fast date in the condo world. First notice 60 days gives a notice of intent to be a candidate, giving you have to submit that by the 40th day prior to, and that date should be correct and listed in that notice. Then it also says that if you, in that same notice, if you desire to be a candidate, you can submit a single sheet, 8.5 by 11 candidate information sheet. Your resume, if you will, or why you're running. And that is, by the way, that is a document that is not edited by the association or the management company. Mm-hmm. It's not anything that you're supporting. So because the reason I bring this up, to address anticipated questions is someone will submit this 1-page sheet and it will contain allegations that may be false. It will contain misinformation that isn't where the association is not in a position to not put that in or edit it in any way. They can counter it with a letter that goes out and clarifies if they want to. But quite frankly, if they want to address something in there, I would recommend they do get with association counsel to ask the best way about that. But those candidate information sheets go out in the second notice. The second notice now can be sent out anywhere from a minimum of 14 days to a maximum of 34 days before the date of the election. And in that second notice, and this, by the way, presumes, of course, that you had more candidates than there are seats. If you have 5 seats open and only 5 or 4 or less submit their notice of intent to run by the deadline date, then the second notice basically is just a revised notice that says we're going to seat the board. There is no need for an election. You don't need to mail out envelopes or ballots because there is no election. But under the presumption that you have more candidates than there are open seats, the second notice goes out. It goes out with an instruction explaining how the vote should be done. It goes out with the ballot. The ballot is listed alphabetically by last name. It goes, and it does not on the ballot indicate who your incumbents are. It does not, it's just list the names. It includes every candidate information sheet that was timely submitted. And once again, timely submitted. And then then envelopes. And the way that, in order to keep the election anonymous, the way it should be done is you have two envelopes that go in the package. You have an inner envelope, which just says the word ballot on it. It's what we call a blank inner envelope, the word ballot on it, smaller, and that fits the ballot. Once the person fills out their ballot, it fits the ballot. That ballot, once completed, that inner envelope is sealed and put in a larger outer envelope. And that outer envelope is where it contains lines and should contain lines for the individual to write their name, sign their name, put their unit number. And as Andy mentioned earlier, an extremely important point is if your community uses voting certificates, and what that means is, say your governing documents will set this forth, and they vary, and these vary. Some of our communities will have a husband and wife must have a voting representative. So that means if a husband and wife own the unit, there's a certificate on file signed by both the husband and wife listing either the husband or the wife as the voting representative. So if your governing documents use voting certificates and you've been following your governing documents consistently, then the outer envelope should be signed by the person, either the husband or the wife who's listed as the voting rep. I had a situation just came up where both husband and wife signed, and the volunteers asked, "What about that?" I said, "That's fine. They're over. It's an overdoing, but at least the voting rep signed it. The fact that someone else also signed it just means they're in unison." But in some instances, governing documents may say if it's a husband and wife, either can vote. You don't need a certificate on file. And the only reason you would disregard their vote is if they both submitted a separate ballot. Okay.
Well, if we back up to your point about the information sheet that gets submitted, how many days do you have to submit that information sheet before it becomes too late?
5 days. So the way it works is you have your 60, 40, 35, and then 14 to 34. And what that means is first notice goes out at 60 days. 40 days is the cutoff to put your notice of intent in prior to the date of the election. 35 days prior to the day of the election is the cutoff to submit your candidate information sheet. And then from the next day, day 34 down to day 14, you can mail out that second notice package.
Okay, and I don't know if I've told you how great I am, Michael, but I just can't fit all the great things I've done on an 8.5 by 11 sheet of paper. So I want to submit more because I really want you to know how terrific I am. What can I do to expand my dossier?
Shrink your font.
Exactly.
Can I use both sides of the
No.
8.5 by 11?
No, you
You cannot. And Andy pointed out earlier, the Florida Administrative Code. The Florida Administrative Code, and I believe it's 61-23. Is that right, Andy?
Yes.
61-23 in the Administrative
B.
Code.
It's
61B, thank you. 61B-23.0027 or somewhere in that range is the Florida Administrative Code, and that piggybacks or supports it's sort of like rules and regulations in an association. You have your declaration of condominium, and then you get your rules that supplement it. Well, you have your Florida statute 718-112, and then you have the administrative code, which supplements how the process is run. And it's very specific. It's a single sheet, 8.5 by 11, one side.
Okay, that's an important clarification. You get one side.
Mm-hmm.
So if you fill out two sides, do you throw it out or you just pick the first side that looks like it's the original description of what you do?
Andy, you have a thought?
Yeah, so there isn't any magical answer in the statute for that. If there's still time left, it's still within that 35-day timeline. I certainly don't have any issue reaching out to the candidate himself or herself and say, you're only get one page. You have until this 35th date, turn one in, that's one page. If there isn't any time left, I would just go with the very first page without any, there isn't any guidance on there. And I think the safer approach is to absolutely you want to include at least the first page, because if you don't, and a candidate submitted a candidate information sheet and you don't include it, and the second notice is sent, that's a possible that's a possible cause for someone to make an election challenge. And we want to get rid of any possible ways that someone could make an election challenge, and not including a otherwise properly timely submitted candidate information sheet is definitely a reason that someone could file a challenge.
A successful challenge.
A successful challenge.
Because we all know people can file for anything.
Anything. And also,
That's actually a good segue into my next question, which is what would cause an association to have to reissue ballots and decertify the election? What typically happens that would say, you know what, guys, we got to kind of start over. Ballots need to go out again. We need to start the 60-day process.
Sure. And Michael, certainly chime in if I don't list every single one, but the timeframes are, as Mike said, a hard and fast rule. So the second notice must be mailed at least 14 days prior, not 13 days. So if it's mailed too soon, that's absolutely a good reason that someone could file a successful challenge. You would need to redo it again. Another common thing we see is the ballot that is sent out does not include all of the individuals who timely submitted their intent form. So you have
Andrew, here's a question that came in from Paula. She says, what happens if the package that was mailed does not include the 2 envelopes that go with the ballot? Is an example ballot included in this package?
Right. So that's a specific fact pattern. If there's still more than 14 days out, the easy answer is just to resend those envelopes out. And you want to notice owners in every way you can: regular mail, email, blast. Envelopes are included. They're also available at the management office. If the outer envelope wasn't included and there's less than 14 days, and Mike can certainly chime in, I would advise you want to redo the second notice again, because there's not enough time to do it correctly. The law requires there to be those envelopes, and the outer envelope especially, because that's the one that needs to be signed by the authorized owner for that unit. So if you don't have that outer envelope included and there's less than 14 days until your election, we would advise you want to start the process again from the second, reschedule it for a date more than 14 days out.
Yeah, Tim, and to your question, in your question you had asked, when would you go back to first notice and open, and because remember the difference between the two obviously is when you're going back to first notice, you're opening up the ability for candidates to be putting their names in who didn't the first time. And so there's in my experience, there's very limited reason to go back to first notice. As Andy was just pointing out, there's more reasons where you would have to cancel and reschedule the election for additional 2 weeks because you didn't, as Andy mentioned, you didn't have the ballots. You left out a candidate information sheet that was timely submitted. That unfortunately does happen. And if you don't include all the names on the ballot and or all the candidate information sheets, and you have less than 14 days, you need to send out an amended second notice. You'd cancel it, you'd extend it. If in fact you mailed everything out 4 weeks in advance and someone brought it to your attention that you left out a candidate information sheet, well, because you have more than 2 weeks left, you don't have to change the date. You would have to do an amended second notice, which would very clearly indicate why you're sending out this amended second notice package. And there you run into the issue that we've had different ways of trying to address is how to make sure people don't vote twice. So in that instance, you probably change the color of the envelopes, you change the color of the ballots, and you inform people to disregard the first notice package and only use these ballots and these envelopes, and in particular the envelopes, so that we have used only your blue envelope, not the white, yellow ones we previously submitted. So it's easier when you're verifying that you have the right envelopes. But that's the kind of situation you'd address on a case-by-case approach. The only time I've seen where the 60-day notice had to start over, and I'll say for me, and if you have another example, Andy, is where there was proof, there was supported proof that the first notice wasn't mailed to all the owners. And so some owners could claim, I never got the first notice. I never had an opportunity to submit a candidate information sheet. And that challenge was upheld as valid and requiring it to go back to first notice.
So Gail's asking the question, I think is along those lines. She says, what if management and the board have no real plan and are late with the first notice, and we fear the second notice and candidate for election will be late? I mean, if the first notice is late, then you got to start over anyway because you don't
Exactly.
have 60 days. So you have to restate the date to get to 60 days. So,
Exactly.
Right,
Tim,
and
I want
the-
to add a scenario to that too, if maybe they can help answering, which would be a scenario where the first notice contained the dates that were incorrect for those specific dates as to when you need to submit certain documents. So if you're reaching out to your members and saying, if you'd like to submit your nominations to be a candidate, you must submit by X date. So if those dates were in error, in other words, we miscalculated the dates, just for clarification to members that may be listening, would that also constitute a need to reissue that first notice? In other words, you have to submit your notice of intent by 40 days, 35 days, but we actually, there was a miscalculation on the dates.
See, and let me clarify that. I think the situation is the better way to present that is that, to me, that raises the possibility of somebody raising a challenge that could be found to be successful. So the way we presented, listen, it's not our job to tell you guys yes or no. It's our job to fully inform the board and their business advisors, which is you guys, as to the issues, the risk assessment, and then so that they can make a fully informed business decision with your business guidance. And in that situation, it really depends on the community and what we're talking about. Is it a hotly contested? Do we have someone or someone's in that community that we know are going to challenge whatever we do? And in that regard, you're probably better off just going back and doing the first notice, because there's really no harm, no foul, other than some mailing costs. I don't know if Andy, you have a different thought.
No, I think you absolutely want to send a clarifying first notice with the correct dates. Whether you need to change the date and time of the originally scheduled date just depends on how much time you have. If it's less than 2 months, you would need to choose a brand new date.
Yeah.
But I think it's certainly a good idea. You want a clarifying notice that's got the accurate dates on it.
All right, so we spent a lot of time on what could go wrong and the dates. So let's assume everything runs smoothly and we're receiving ballots. Where should ballots be accumulated and stored to be in a secure place so nobody can accuse anyone of tampering with the ballots coming in?
Tim, before we do jump though, I did want to say we focus on condos, and I just want to remind you, because we have some HOA listeners as well. I don't want to leave them out, right? We have a bunch of homeowner association board.
Yes.
Yeah. So I think that we do need to point out in the HOA world, you really do need, as we mentioned earlier, to review your governing documents. Because I have seen HOAs that run like a condominium and require the 60, 40, 30, and those have all primarily been done by amendment. And quite frankly, I have a few we're working with now who are looking to amend to that process so that they can hold elections. Because one of the things that we didn't hit on yet, but we should, is quorum requirements for condos versus HOAs. And really, quite frankly, you don't have a quorum requirement for a condominium election. You have a minimum number requirement, but not, and we can get into that in a minute. But for your HOAs, you got to review the documents, because the statute basically says follow your bylaws. And, like I have a community that says the membership meetings, which include the annual meeting, only need 7-day notice. So they have noticed their annual meeting with 7 days notice. If people show up and they have quorum, they take nominations from the floor, and that's how they run their election. So it really depends. You really want to know what your documents say and how your documents read, whether you need nominations from the floor, whether you can avoid nominations from the floor. Very document specific if you're in an HOA. Sorry, Andy, you can ask the other question.
So Angela has an interesting question along these lines. What if a person, if the unit is registered to a corporation or an LLC, and somebody wants to run for the board, how is that? Are they allowed to run for the board when it's named as an LLC or a business name?
Right. So that is a very document specific thing. There is no statute either in 720 or 718 that speaks to that. When I first started talking about it and I discussed the eligibility requirements, I cannot tell you how many clients where I've had to be the bearer of bad news when a non-owner throws his or her name in the hat and they want to run for the board. And they say, Andrew, can you believe it? We have someone that just rents and he wants to run. And obviously that's not allowed, right? And I have to say, well, actually, eligibility, whether you have to be an owner or not, is document specific. You need to confirm whether your documents require board members to be owners. Most of them do, but not all. So going back to whether someone who is the president of a corporation or is the managing member of a LLC, all of those things, whether they're eligible or not, that's going to be document specific. So I encourage that board member, get with your association's attorney, confirm whether they're eligible or not. And I also want to mention, Mike had talked about for condos and co-ops, obviously, your notice of intent must be submitted 40 days prior. Anyone who wants to be a candidate needs to be eligible on that 40th day. And there's language in the statute in 718 that says if you're delinquent in any association obligation, so if your assessments, you're past due, even technically $1, if you're delinquent on that 40th day, you're not eligible to run for the board. So if you're a condominium manager or you're a member of a condominium board, when you get all of your notices of intent to run, you want to make sure you have your current financials ready to confirm that those individuals aren't past due. Because it's not an optional thing. It's not like the board can say, well, we really like John Doe, even though he's, $1,000 behind, we're going to allow him to run anyway. So I just wanted to sort of point that out. For HOAs, you have to be current as well. You can't be behind in order to, run or serve. So if you're an HOA and your documents allow nominations from the floor of the annual meeting itself, you want to make sure you have the current account ledgers handy, because if someone raises his or her hand and they're not current, it's a little bit awkward, but you need to inform them that they're not able to serve. So I just wanted to point out those eligibility requirements.
Zuly, so once election ballots start coming in, what do we find as a practical best place to store ballots so that they're not tampered with?
So we have associations that actually have ballot boxes. More and more we have associations that have gone towards the electronic voting, Tim. So that's definitely something that we promote highly, electronic voting and communication. But for those associations that are still doing the paper documentation and process, we have many that have ballot boxes, but our management team does find a secure location where both the board and the management team understand this is not obviously something that the board is overseeing, especially if our board of directors are part of the candidate pool. But the management team sources those documents in a secure location within the management office so that no one, especially none of the residents, have access to that. Obviously ballots cannot be opened in advance nor reviewed in advance. So the only thing that is done in advance is to register the fact that they have been received and acknowledged, but they are not opened. So definitely secured within the management office in a file or a box. And so we start to really control the organization of that process.
Michael, do you have anything to add to that? You look like you're.
there was a question on the
Okay.
panel there that was clearly a message to me. So how you doing, Darren? No, as far I will say that when this comes up, when it comes to us, and it's often dealt with internally, but when it does come to us, I have had situations where when the community is so untrusting, which is unfortunate, that they'll have a locked box and they'll have the key delivered to our office, so that that it can only be open when we come to the meeting and we open the box. But the one situation I did have recently where where people were raising concerns about the ballots. I said, you have to have your ballot box accessible if people want to drop their ballots in. So put the ballot box in a locked ballot box in a place where there's a camera on it 24/7. There are cameras, if there are cameras around the management office or outside the management office, which there often are, then have the ballot box in a location where there is cameras 24/7, and that usually will alleviate the people's concerns that there's been tampering.
Okay, thank you for that. I want to move quickly. We've got a lot of questions to get to that are pouring in. So I do want to get some definitions from you guys, if we could, on there's something that goes out called proxy statements. And what is a proxy? When do you need a proxy? And how are proxies different for condos versus HOAs?
Sure. Well, I think one important point to note is for condominiums, you cannot vote for the election by proxy. And that's clearly expressed in Chapter 718. So the only way an owner can vote for the election in a condominium is the ballot and the inner and outer envelope process. If you're voting on other items at the annual and you're in a condominium, a limited proxy can be used if you're voting on amendments, let's say. And a limited proxy is where I'm an owner, I'm unable to physically attend. I vote how I want on those amendments on the limited proxy form itself, and I give it to whoever the proxy holder is, and that proxy will establish that'll establish for quorum, and it'll also establish how I want to vote. Again, for the election in condos, you can't vote via a proxy. For HOAs, it's document specific on how the election process works. Oftentimes in HOAs, the documents do allow owners to vote via a proxy form. In fact, it could be done what's a general proxy, where you give your general proxy to the proxy holder, and the proxy holder, him or her, cast the vote for you in any way that the proxy holder wants. So if any of us have ever been involved in a contentious HOA election, we might have some stories about one owner who brings in 100 proxies. They went around the community, they knocked on doors, and they got owners to give him or her their general proxy. And then that one person could cast 100 votes on how he or she wants. I've also seen, and again, this is all document specific stuff. So you need to, if you're in an HOA, you got to make sure you have your governing documents reviewed. But I have seen where the governing documents restrict the number of proxies one proxy holder can have, let's say to a total of 5. And that will help any problems that there may be with someone running around gathering lots and lots of proxies. But the main takeaway to me is in condos, proxy voting for elections is not allowed.
And I just want to, and I'm glad you mentioned that last thing, Andy, about the limitation on the number of proxies, because that's something that I think people get caught with unexpectedly. It's not in a lot of documents, but it is in some. And where it can really be a hiccup is proxies generally are, as you all probably know, when proxies are drafted, it says fill in the name of the proxy holder. If it's left blank, it will default to the secretary on behalf of the board, or words to that effect. if there's a limitation on the number of people, number of proxies that one person can hold, and it doesn't exempt the association from that limitation, you need to make sure that the secretary is aware of this and has people that they can substitute out. So it's 5, 5, 5, 5. I was at a meeting where they had to do that once. They, when I got there and I reminded them of this, they forgot it. There was a substitution. So we sat there. Fortunately, there were 7 other people who were like-minded, I suppose, who they were able to substitute out. But you do need to, that's a really good point Andy brought up, is, and it reiterates, we're beating it to death, but with good reason, is the importance of knowing your governing documents. Zuly started out with being prepared, and that is the best way you can be prepared, is by knowing and understanding your governing documents. And board members, it's not your manager's role to interpret those documents. It's their job to help guide you. And managers, you of course are all, with your management license, with your education, you certainly can read and interpret, but I would recommend that you say to them, here's what I'm seeing, but we should get opinion of counsel. And then if you get it 1 year and nothing's changed, you can certainly lean on that opinion in following years. But I would certainly, that's my recommendation, to best protect everybody.
Okay, so following up on that, there's a question from Sandra, who's in an HOA, that indicates that their ballots and proxies were sent in error. Can it be corrected by sending out secret ballot packages, even though there are fewer than 14 days prior to the election?
I didn't get the first part, but I think we did. Isn't that we addressed this already? That if the package is mailed out improperly with less than 14 days, then
Yeah, I think she was in an HOA, which makes it somewhat problematic to give her direct answers, because it's really document specific. But if the governing documents in the HOAs requires a 14-day advance notice, and there was something wrong and there's less than 14 days, they would have to do it again. And also, this is probably a good point where I know we usually give our attorney spiel, which is, this is obviously general information.
We're supposed to do that before. We always forget.
We always forget. So this is
informational purposes.
This is for information. So it wouldn't be appropriate for a board member out there to go back to their other board members and say, I met with an attorney today. We got advice. This is how we should handle it. You should obviously get with whoever your current counsel is if you have a very specific fact pattern, especially if you're in a HOA, because it's so document specific.
Hey, Richard's asking if his unit's owned by a revocable trust and he's a trustee, can he legally vote, and can he be a candidate for the board?
Well, I think we go ahead, Andy.
Yeah, I think we sort of touched base on that. That's a similar fact pattern. If a unit is owned by a LLC or a corporation, usually trustees are considered, in essence, the owner of that property, and it would be proper for that person to vote and to also serve on a board. There is actually a pretty obscure Florida statute that talks about trustees being eligible to serve on a board. But again, your particular governing documents may have some quirky language on who's eligible to serve. So you want to definitely review those.
Okay, great. Let's talk about quorums for a minute. What's a quorum, and what's it mean if you do or don't have a quorum in an HOA versus a condo?
Okay. Condominium statute's very clear. In order to have a valid election, at least 20% of the eligible members must have submitted a ballot. So it's 20% of them. You have 100 units. If 20 units submit ballots that are that the outer envelopes are all valid, then you have your election. Quorum in a condominium is majority unless there's a lower percentage in the governing documents. So quorum, and the only reason to establish quorum at the annual meeting is if you have other business other than the election. So if you say that you're voting on amendments, or you're voting on a reserve question or a material alteration question where you need a majority of the membership present to be able to have a vote. If you don't have quorum and you have enough ballots to move forward with the election, you move forward with the election, which, by the way, if you notice in the condominium world, the agenda for your annual meeting should be appointment of inspectors of election, commence the election. That goes first, then it's established quorum. because you don't need to have that quorum established to run the election. You only need 20% of the eligible voters to have submitted a ballot. Okay, if you then establish quorum, then you go through officer reports, committee reports, whether there's any old business from last year, if there's any new business from a membership meeting standpoint. I will tell you candidly, often I see none. They really are just there for the election. That's the business. So that's the condo. HOA is different. HOA, again, unless your governing documents have specific language that presents certain requirements, like I said, mirror the Condominium Act. In general, in HOA, you have to establish quorum. Quorum in an HOA is 30% of the membership, unless of the eligible members, unless a lower percentage is in your governing documents. So for this purpose of this discussion, 30% is what you need. And if you have quorum, then you can hold the election. If you don't have quorum, then under the current statutes, there is no annual meeting that's able to be called, and the board that's in place as of that date, which is the prior year board, will roll over.
Okay, thank you for that. Let's talk about electronic voting. I think we'll probably spend the rest of our last 15 minutes on electronic voting. We have a lot of questions about
I saw them, yeah.
Yeah, and I will say that from our poll questions, this is interesting. I said it was election season. 72% of the people responding have their elections in the first quarter, January, February, March. 32% have their elections November, December. So that makes up, and then the other months have 1% each that have responded today. So again, this is a very timely conversation because a lot of elections are going on right now.
Did we ask how many, did we ask how many do electronic voting now?
That's my next one. Electronic voting. Of the group that we have answering questions today, 21% are doing electronic voting, 79% no. So, and 49% use their attorney or a moderator for the election, and 51% use nobody. They do it themselves. So those are kind of interesting stats that you guys might be interested, that you guys would probably be interested in. So with that, let's talk about the electronic voting side of things now.
Can I rapid fire a few of these?
Yeah, please, just start firing away.
All right, well, because Paula asked, can association mandate electronic voting? No, an association cannot mandate electronic voting. What a board, whether you're a condo or HOA or cooperative, the way you do if you want electronic voting as an option, then this current statutes require that the board hold a properly noticed meeting of the board of directors. And by the way, that is a 14-day notice that is mailed and posted, where the agenda includes that you're going to adopt a resolution to allow for electronic voting in future votes. And by the way, remember, that's not just for elections. That's for, I think it comes in most handy for amendment type votes and things of that nature. So it's not a mandate. If the board does meet and adopt a proper resolution and then send out the proper documentation, what you're doing is giving your membership the option. If someone wants to vote by paper, they can continue to vote by paper. So that's that one. Let's see. Andy, there was another one here. I was going to, oh, you want to explain the steps necessary for the electronic voting?
Well, no, I think that's exactly right. It's an opt-in process. The board, first of all, approves even offering it, and then it's an opt-in. You can't force someone. So people who like the old school way can still vote the old school way. But if you are a community of any size, it obviously, electronic voting makes things easier. I mean, that's the whole goal of it. It's obviously, I do get questions from time to time. It's not as simple as you replying via your own email how you want to vote. There needs to be actual software. There's lots of third parties out there that provide electronic software. And I suspect, Tim, that number, you said it was in the 20% of the number of communities who now use electronic voting. I suspect that number will go up year in, year out. The communities that do use it, and you get the majority of owners opting in, it makes things go a lot smoother, a lot faster. The email addresses are kept private, so it's not like the board gets to see how you cast your vote. And also, it can be used for other things. It's not just the election. If you have amendments you want to, have done, if you're a condo and you want to maybe partially fund reserves, or you have a material alteration vote. And a lot of these questions oftentimes fail, not due to people voting against it, just from owner apathy. They're just not involved. So I think electronic voting can certainly increase that. And really at the election, when the polls are closed, you press a button and those electronic votes are there. You may still have some old school envelopes that you need to open up, and that's fine. But I definitely think electronic voting is something boards should look into.
Right. And the process, as I was mentioning, is there's the resolution, the board would adopt a resolution, and the resolution and the statutes specify, you know, so the statutes, you can read in the statutes that they specify the resolution is going to approve the vote, electronic voting, and set up essentially a basic process for members to be able to opt in to vote electronically, as well as opt out if they want to. And so like Elsa asked, do we have to have a specific document signed by the resident for them to do email voting? If we already have an email authorization, can we use that, or a special document is required? So if someone has already consented to use their email for as their official address, that's fine. That's that's part of the official records for notice requirements. But I believe if they want to vote electronically, then they'll have to opt into that, because as Andy mentioned, there'll be a separate software program, and the software company will be given a list of the names and email addresses of those individuals who have opted in, and they will then communicate to those individuals, here's the documentation that you need, here's how the process works, you know, test your system, make sure it works, type of thing, and then submit your vote. So you would even if someone has given their email address as part of the official records, they still need to opt in to vote electronically.
Michael, as a best practice, what we have found, and again, this is property specific, what works best for them, and their association attorney consults, but if they haven't done either one of those and they want to pursue that, they would definitely have to have the members opt in to both electronic emailing or communication and then electronic voting. But they could consider passing both of those at the same time, so the owners can opt into both at once, so that you can save time.
Right.
So,
well, we recommend that, right? Because what we've done, so like, you know, if a board does decide they want to move forward with electronic voting, I just had this question come up. I said our recommendation is to then allow your attorney to assist putting together, the notice is a board meeting notice, that's gives me the agenda, but the documentation, the instructions that you want to be able for the board to be able to address the resolution properly, and then the notifications that you'd send out to the membership, that's something that you might ask council to put together to make sure that it meets all the requirements. And one of the points we do make on there is really right on with what you're saying is inviting the individual not only to opt into electronic voting, but to also consent to having their email be used for official, as consent to have the email as part of the unit owner roster, and then letting them know this means it's part of the official records. So,
right.
But I think, and I think in today's world, more and more people are doing that. Even if they create just an email for, like, you have board members creating emails just for their, association, like President at, you might consider as owners creating a separate email, for your association and using that email address, and then that's where all your association stuff will go.
And so along those lines, Michael, Bill in Miami is asking to discuss privacy aspects for electronic voting. Like, will my email address be disclosed?
Not if you only opt into electronic voting.
Okay. I want to answer this question quickly for Brenda in Bonita Springs, because she wanted to know if this meeting today, this webinar, serves as board training based on statute 720. The answer is no. We'll do that on March 3rd. So there is none. This doesn't qualify for board certification. It's just educational. Carol in Winter Garden wanted to know how do we justify the expense of electronic voting over traditional paper method? Zuly, do you want to talk about that? Because you're not going to have to mail out as many envelopes. You're going to save on postage and paper, and it can help pay for electronic voting.
Right. So what we have found is that the cost of most of the companies that are out there for the software and the service is far less expensive than the standard cost of your typical mailing. whether it's your budget mailing even to that extent, or even your typical annual meeting mailing, it tends to be far more expensive. Your routine mailing, no matter the size of your community. So that alone is a cost savings. So you just have to look at your budget line item for postage and paper and the like, and compare that to the pricing of your typical simply voting or electronic voting or that type of software.
All right, and then Matthew's asking if you sign up for electronic voting and you missed the date to get your electronic vote in, can you show up at the manual meeting and vote paper?
Sure.
Yes.
Okay,
Sure.
so you can.
Yep.
You just can't do both.
Right. You just can't vote both, and it's the first vote. So once your ballot is submitted, it cannot be rescinded or changed. We get asked that a lot in an election. Once that ballot is turned in, it's done. Unlike a vote via a proxy on an amendment, you can change your, vote via proxy as many times as you want before the vote actually happens. But for the election, your ballot cannot be changed or rescinded.
Okay.
I got a couple for you, Tim. I'm looking at. Gail asks if it happens if you don't have 20% of the owners voting in a condo. While that is rare, it does happen. And ultimately, in my experience, again, remember this too. If you're a candidate for the board, I mean, if you're a sitting board member and you want to, and your seat is up, make sure you submit your candidate information sheet timely. But if you don't have 20%, it's the same situation as in the HOA. You don't have, it's effectively you roll over, and the board can decide to set the election again, just like they could in an HOA, but I don't think they're mandated to do it. If you don't get 20% of the owners voting the first time around, I think the board can just stay on another year. Andy,
Yep.
do you have another position?
Correct. Nope.
Okay. And then there was a question about can you vote? Someone asked, can you vote a slate, president, vice president, secretary? And I just want to point out, in the condominium world, you're voting for directors, not officers. The directors will then sit around a table either the night of after they're elected or within 10 days of the annual meeting. That's called the board organizational meeting, and the directors will choose their officer positions. In an HOA world, that could work the same way, although there are some HOA governing documents, and Andy and I have beat this to death, but it is true. So you have to read those documents because there are some HOAs that do vote that way. You nominate yourself for an officer position. So you run for president, you don't run for the board. And if you're elected president, you're now a sitting director. So it really does depend if you're talking condo or HOA. Condo, definitely not. HOA, maybe.
Chantal's asking about quorum, and if the bank actually owns one of the units via foreclosure, is the bank considered as a count for quorum, or is the quorum adjusted?
No.
Well, whoever the record owner of that property, that's what's counted for quorum. So if certificate of title has actually been issued to the bank, they're considered an owner, and you wouldn't adjust your quorum count. They would be counted
Yeah,
as
300 units, it's still 300 units, even if the bank.
Yeah, what that person might be
Yep.
thinking of is there's language in the statute that says that you wouldn't count an association owned unit. You'd reduce that if the association owns units, you reduce those from the number of units, and that would reduce the quorum requirements. But any third
not
party
the-
owner is an owner.
Mhm.
Can notice of a meeting be sent via email?
if the owners provide their specific written consent to receive notices via email.
And that's where their email becomes part of the official records and part of the roster. And someone asked, in the event of a resignation of a director, what's the best way to fill the opening, which is not quite the election question, but I think it's very relevant. And again, in the HOA, in homeowner association, you're following your governing documents again. In the condominium world, the statute provides that unless your bylaws provide otherwise, then it will default to the following. And so it's important that in the condominium world, you do read your bylaws, because the default is if you have a director resignation, the rest of the board can fill that vacancy. and that vacancy would be for the remainder of the term. So if you have staggered terms and I get a 2-year term and 2 months in, I move. And so now you can fill the vacancy for the 2-year term. That would be the default. But the language in the statute that says unless the bylaws provide otherwise is our cue. We got to look at bylaws. We have several clients, some of whom have amended this to mirror the bylaws now, to mirror the statute now, because their document said that the directors would fill the vacancy until the next annual meeting requiring a special election, and they preferred it to be filled for the rest of the term. So you really have to determine, or if you prefer it be that way, you amend your documents to read that. So that's the difference again, as far as if you have a resignation, the best way to fill the opening is the rest of the board will fill the opening for the remainder of, at least the remainder of until the next annual election, possibly for the remainder of the term, depending on how your documents read.
Okay, we're at the top of the hour, Michael. I know you've got commitments, so I'll just ask one final question to all of you. I'll start with you, Zuly. What's one thing you can recommend for the best practice to have a fair and honest open election where there's not too many questions from the ownership group?
For me, first and foremost is it all starts with good communication, proper planning, and collaboration amongst all involved. We don't all have to agree. And what I mean by that is amongst the candidates, I know that sometimes it can get rather tense in our communities. So we don't all have to agree, but we definitely have to work together towards what is best for our association. So again, we have to work together. So it's all about communication, proper planning, and transparency. So the more informed we all are and the more informed our members are, the more successful everyone will be in the end. So allow the management team to plan and to work together with our professional partners, which would be the attorneys and other parties involved to work on your behalf.
Okay, Michael, I'll give you this.
I'll let Andy speak for the both of us on this one.
I don't know about that. He'll probably chime in with something good, but
nope. I'm good.
For me, if you're thinking about electronic voting, start now. Even if your election just happened and you're thinking about it for the following year, start the process now, because I think that'll help a lot. If you don't have electronic voting, we don't like surprises, as I said. So have your current owner roster ready and available. Make sure you know what the voting certificate requirements are. And if you're in a condominium, think about verifying the outer envelopes early. You can do it the same day. It could be a couple hours before you notice a meeting. There's an independent committee that the board appoints. Have that independent committee meet. You post notice 48 hours prior, and they verify the outer envelopes. Let's say your annual meeting is at 5 o'clock. You have this independent meeting at 4 or even earlier. Get the verification process done. All the envelopes are checked in. That way, when the annual meeting starts, it's a much smoother ride.
Great. Thank you very much, Andrew. So we'll wrap up. We had a great session today addressing the best practices for managing board elections. I have to believe that our listeners got tremendous value from all of you today. So thank you. I want to sincerely thank all of our participants as well as the panelists. Special thanks to Michael Bender, partner, Andrew Black, a partner with MBender Rembaum, and Zuly Maribona, Senior Vice President and partner with KW Property Management Consulting. You guys were fantastic. Thank you.
Thank you.
Session is recorded.
Thank you.
You can watch this broadcast again or share it with a fellow board member. You can find it on our website at kwpmc.com and our YouTube channel at KWPM TV. Don't forget, you can.
And we'll link it on our website.
Yes, you will have it on your website too.
Sure.
And the MBender Rembaum website. Don't forget, you can get your free COVID test kits if you want one at covidtest.gov. We don't always get freebies like that, so I'm making it out, putting it out there, everybody. Again, we look forward to having you join us again next month on March 16th as we continue best practices for community associations, the third Wednesday of the month from 3 to 4 o'clock. From all of us at KW Property Management Consulting, you can also join Andrew Black and myself on March 3rd for our board certification course. It's going to be a 2-hour course starting at 10 a.m. Please join us. For all of you in HOAs, co-ops, and condos, please be respectful neighbors and stay healthy. Thank you, everyone. And we had a great crowd, great session. Sorry we didn't get to everybody's question. We did the best we could. Thank you so much, everyone. Have a great week.
Thank you. Thank you.
Thank you so much.
Bye, everyone.
Bye-bye.